This is Technically Legal, a podcast about legal technology, innovation in the legal industry, and the impact tech is having on the law. I'm Chad Main, the founder of legal services company Percipient, and on today's show, I've got an all-star panel that's going to talk about the intersection of AI and rules forbidding the unauthorized practice of law. We've got strategic advisor and author Ken Crutchfield, Indiana University law professor Bill Henderson, and ethics attorney Jim Doppke. So, I think the advent of LLMs, aka large language models, might be bringing the law full circle. So what do I mean by that? After recording this episode with my guests, I did a little research, and here's what I learned. In ancient Greece, citizens were expected to argue their own legal cases. But as laws became more complex, citizens could enlist the help of orators, or friends of the court, to advocate on their behalf. These were the predecessors of the modern lawyer. But, unlike the attorneys of our age, the orators in ancient Greece couldn't be paid. So many didn't recognize it as a profession. Let's fast forward a little bit to the Roman Empire, sometime around 47 AD. At this time, advocate and orators were still involved in the process, and they still couldn't charge fees. But around this time entered Emperor Claudius. He said the friends of the court and the orators, the advocates, could charge fees, but they had to put a cap on it. And if they didn't limit what they charged, they could be charged with extortion. Now I'm going to jump ahead centuries to the modern times. It's no secret that for a while, attorneys' fees in America and elsewhere have been really expensive and only getting more expensive. And not only are legal fees high, there are rules that give lawyers a monopoly on legal work. These are called UPL regulations, or rules that prohibit the unauthorized practice of law. For the best I can tell, these UPL rules started bubbling up in the late 1800s and early 1900s. Looks like they started in New York. But just a couple decades later, pretty much everywhere in the country had similar laws preventing the unauthorized practice of law unless you were a licensed attorney. So let's get back to my comment about AI bringing some parts of legal representation full circle. Just look at your favorite news outlet, and within the first 7 articles, you're going to find one about how AI is going to disrupt all professions, legal included. But when you think about disruption, you think about what are now huge companies. You think about how Netflix beat up on Blockbuster when it was still charging late fees, or how Uber rewrote the rules for the taxi industry by simply acting first and asking for forgiveness later. But what happens when this beg for forgiveness MO hits the practice of law? What happens when a large language model, which is a generic technology that doesn't sleep and doesn't bill by the hour, starts answering the questions that only lawyers were permitted to answer before? And what happens when, armed with these answers, people head to court? It's kind of like having one of those ancient Greek orators in their pockets. And that's where I'm going with my idea about AI taking law full circle. Specifically, what happens for certain types of legal matters when you can DIY with the help of Claude or Gemini, and you don't need a lawyer? And let's be completely honest, a lot of times, for a lot of people, even if they wanted a lawyer, they couldn't afford it. So, how do regulations that are over a century old, barring legal advice from those that are not lawyers, come into play in the AI age? To talk about that, I got 3 great legal minds together who are all uniquely suited to talk about it. I was inspired to put this episode together after I read a series of articles by Ken Crutchfield. The articles addressed how AI is pushing up against the boundaries of UPL regulations. So, after reading these articles, I reached out to Ken, and he graciously agreed to come on the pod. He's a consultant and strategist to the legal industry, and as we will hear, he also thinks that law is a system ripe for change. I also asked Indiana University law professor Bill Henderson. He's the mind behind the very well-read and respected Legal Evolution website, and he's been trying to tackle access to justice issues for many years. Finally, I asked my good friend and the very first guest ever to appear on Technically Legal, Chicago ethics attorney Jim Doppke, to come on. Before he went into private practice, he was a regulator at the ARDC, which is the legal body charged with regulating lawyers in Illinois. On today's show, the guys are going to talk about why the boundaries of unauthorized practice of law rules might soon be defined more by what regulators must allow rather than by what they can restrict. For instance, we'll hear about an eviction proceeding in Long Beach won entirely with ChatGPT. We're also going to hear about a bankruptcy lawyer who thinks his future job will simply be fixing the forms the AI got wrong. Today's conversation is about the 2 hemispheres of legal practice. On one side, we got organizational clients who often want someone to blame when things go south. And then on the other side, we got what Bill Henderson calls people law, the underserved clientele who just want an off-ramp from a system they can't afford. As I always like to say, this podcast is about the impact tech is having on the law, and this is certainly a prime example of it. Fellas, thanks for being here. I appreciate it. The reason I wanted to get the 3 of you guys together, because you're well suited to comment on a series of articles Ken has done recently, the third to be released, probably be released by the time this comes out, on how AI is going to change the practice of law, kind of the delivery of work, where it's coming from. But really underlying this too, it's coming into friction, and already is, with rules regarding the unauthorized practice of law. So, Ken, tell me, I'm going to paraphrase basically your point of the three articles is the legal industry is getting disrupted. Work is going to be redistributed. Stuff's going to stay at law firms, but a lot of it's going to move. It's going to move to individual consumers of legal services. And then it's going to move to companies like mine, ALSPs, or I appreciate this point. You point out that the term should just be legal service providers, not just alternative legal service provider. But work is going to move there because tech, specifically AI, is going to permit it. But the thing I wanted to get started with is this is a good quote from your article. Can you say in one of the articles, you say the boundaries of UPL, unauthorized practice of law, in the near term may be defined more by what regulators must allow than what they restrict. So I think what you're saying there is, actually you do say it, Uber. Uber went in there and begged for forgiveness later. Taxi rules be damned. And that's what we're seeing now, right?
Right. This was an interesting one for me because as somebody who's not an attorney but has been around the law and the practice of law and the legal industry for a long time, is I was looking at all the investment that's going into AI technology and legal technology. There's just no math that works that gets a return on investment if it's just replacing other technology, because the spend on technology is, maybe $20 billion across the legal industry, but the overall legal industry is closer to a trillion worldwide. And my hypothesis was the only way that that works is if labor is replaced by technology to get a ROI. Otherwise, there's a lot of venture capital funds that are going to be, scratching their head. So that was how I got into this. And really, looking through, I was looking for where does the disruption actually happen, thinking about it like from a systems analysis perspective, because I have engineering training. That's the way I could look at it as somebody who's not an attorney and try to put something out there. And really where I looked at it and concluded one of the big areas that was going to change was the unauthorized practice of law, partly because technology, a large language model, can kind of answer some questions. It's changed the definition of what can practice law or provide some kind of legal advice. And I think that there's been a number of things around where traditionally lawyers and law firms have done work that wasn't just advice, but was about legal information. They were the ones you had to go to find out what the law meant, for example, or to work through a contract where, a lot of it's business terms. And if you have the proper legal guidance up front, a good sales director can work through a playbook and a series of clauses. So that's really where I looked, and I concluded that the unauthorized practice of law was one of the areas that was likely to bend. I would argue that it is bending right now because you have consumers using ChatGPT and, putting filings pro se together.
You mentioned that in one of your articles, there's a case in Long Beach. A woman went to court eviction proceeding and
Right.
was successful just using ChatGPT.
Right. And then when you come down to it with lawyers using a lot of the same technology, where does the lawyer end? Where does the lawyer begin in some of those? I think becomes, an interesting question. So getting back to the point on the quote about regulators, what they don't do, I think we're in a state of flux where it's kind of hard to decide what is the new future state, and it's hard to regulate in transition.
Can you mention something Bill's pointed out for a while, the medical profession, where historically you had to go see a doctor did everything, but that's morphed. Now you got people come to the house that are medical professionals, but not doctors per se. And it's kind of where probably law is going to go. And actually, it already is in certain states like Washington with those legal professionals. But question to you, Bill, isn't this a good thing? Isn't this a good thing that now there are tools out there that the underserved can use to actually, kind of help represent them in court? Or is this not a good thing?
Well, I mean, I'm putting together a grant proposal for access to justice, and I was using AI to help me. I don't know, it cut the amount of work from maybe 16 hours to 4. And so I'd be a hypocrite if I wasn't saying that it was dramatically helpful. I mean, I was feeding it all the input that I generated, but there's other models that there are other sources of data that was indispensable. I think it's fantastic. And Ken raises, I mean, there's no doubt about it. that people are asking for legal advice and getting it on those models every single day. And so I think the biggest issue here, and I'm not going to even talk from the regulator's point of view, but the revolutionary aspects of AI is I think that large language models are really what might be called a kind of a generic technology. And if you go back to Crossing the Chasm, the famous book by Jeffrey Moore, and he's got this thing where he talks about a whole product solution. And let's think about this for a second here. You have the law, the body of law. This is how things get resolved. But the amount of transaction costs, with or without AI doesn't know way that doesn't take away from the fact that you got to have the pleading, put it in front of the judge, get a ruling, and is that really economically practicable? I mean, so that this AI universe, it has to interface with this arcane Byzantine old system that's probably not going to change anytime soon. And so you're revolutionary up to the point where you hit the courtroom door and the judges are complaining a lot about these uppity self-represented litigants. It was never good before, too many self-represented litigants, but now you have other folks that are coming in with the AI, and it's not necessarily speeding things up in the court. I think the judges would be very skeptical that this is a leap in the right direction. It could be the best option the self-represented litigant would have. Second thing is, I was in my Access to Justice, applied research class just last week. We had a bankruptcy lawyer come in. He does 7s and 13s. And he said that he's convinced his practice is going to be dramatically changed. Just going to Ken's point, going to be dramatically changed. This form preparation can be done through these large language models. And what he says, he thinks his practice is going to be basically fixing the 7s and 13s that aren't done right. And basically, I didn't get the result I wanted. So, lawyer, tell me what I did wrong. And there's a huge amount of tacit knowledge that basically the judgment that you need, because the prescribed legal solution, this is what you get if you take all the steps to completion, it's too expensive. And it doesn't lead to the desirable outcome anyway. And so the lawyer, their big value add is the off ramp. And that's tacit knowledge that can't quite be captured yet. So, we're just not at a whole product solution yet. It's going to take 20 years to build it or 10 years to build it. I'm definitely pro large language model, but we got to build a whole product solution.
All right, Jim, you're up. So before we went on a couple hours ago, Ken sent a draft of a bill that was recently introduced in New York. And I didn't have time to read it, full disclosure, but I read the gist of it. It created liability for chatbots that gave bad legal advice. So looks like regulators are starting to come around this, but you worked at the ARDC in Illinois for a long time. It's the Attorney Registration Disciplinary Commission. So that's the governing body in Illinois for attorneys that are practicing in the state. Put that hat back on. And if you were running ARDC today, what would you try to do to deal with this? That there are consumers that are getting legal advice from technology that is not from a lawyer.
I think if I were running the show, regulatory wise, I would be getting a lot of pushing from a lot of sectors of the profession to regulate, particularly the legal advice from chatbots. I was not surprised to see that the New York proposed legislation, in the sense that, not that I know exactly what their regulatory environment is like, but I'm not surprised that one of the early efforts to regulate AI is about that. And I don't know if anything like that is on tap here in Illinois, but I know my regulatory environment here very well, and it's conservative on these issues. I don't mean politically. I mean, there is resistance to the idea that an LLM could generate legal advice that could be relied on. I think legal information is still another category that falls below that. And the provision of legal information by a tech product or platform, I don't think is seen with the same level of concern, or should be.
Now we actually have to define the line between information and legal advice, which we've never had to do before.
I have trainings that I do where I give it a shot.
So what's your distinction? What if there's trainings you give, like what is in the training? What's the distinction?
Legal advice speculates on outcomes. It deals with particular client facts or hypotheticals and applies the law to those specific facts with a goal of determining what course of action should be taken. Whereas legal information is more general, it's something that can be published by a government and someone can relay what the government says that this thing says, like an immigration firm can have on its website, what's an H-1B visa? And that can be just governmental information put out there, and that wouldn't be regarded as legal advice. That's how I try to draw that. Now, an LLM is going to draw information from a lot of different sources, or it will have, by the time anybody's using it, it will have drawn a whole lot of information. And some of that might be classifiable as legal information. Although, again, I don't say that my definition of these things is like a really bright line test exactly, but some of what an LLM could provide is more identifiable as legal information, but then maybe it starts going into legal advice. And again, I think if I were a regulator, I would be feeling a lot of pressure to regulate the legal advice part, if not out of existence, then because I take your point that it's, regulators are not necessarily going to succeed in doing that, even if they want to.
What about Ken's point, Uber? I mean, if it is what it is, and I still go back to what I asked Bill about it. In my mind, this is helpful. It's helpful to people that are currently underserved.
Yeah. Oh, I agree. And there are a lot of noises made about access to justice, and yet the efforts we make to address that lag behind the need, and they lag behind technology. And I don't know that there's a regulatory solution. Certainly, there's no regulator that can put all genies back in all bottles, especially on the technology front. I just think regulators are feeling pressure to do that because there are sectors of the profession that resist what they feel is work being taken away from them.
Yeah, I know, but this gets stuck in my craw. I remember I was at an event, it's been a while back, it's in Illinois when I was still in Chicago. And you've got these attorneys, and they were all up in arms about the legal professionals that were going to help with certified legal professionals. And they said it's going to take business from us. And the truth of the matter is, they weren't helping those people anyways because they couldn't pay them. So what is that
Yeah.
argument?
Oh, I hear you. It's more of a feeling than a data-driven argument. I understand what you're saying. I'm just describing really what I hear people say or hear lawyers say as part of the objection to the acceleration of AI-driven models. And then lawyers also get all caught up in the errors that LLMs can make. And
Well, humans, come on,
well,
humans
I
make all
know.
kinds of errors.
What I'm saying is, regulators get concerned about that. Regulators who speak to audiences about what's going on in legal regulation now have a portfolio of horror stories they can tell, right, about LLMs that went south on people who, and really the story is about a lawyer who wasn't using it correctly and who didn't check the output that the LLM gave them. But that's another approach that it isn't regulation, but it's something that regulators do. They aggregate these stories and they go around saying to audiences that they talk to, don't do what that lawyer did. At the same time, there has not in my jurisdiction been a prosecution of a lawyer for errantly using technology like that. I believe there was one in Colorado and one in California. The Colorado one resulting in a shorter suspension. And I think I heard about a California case that went to a 1 year suspension. There may have been other conduct involved in that. I'm not sure. But regulators are thinking about these things. If I were a regulator, I personally would want to come up with a regulatory regime that was not focused on stopping all of everything entirely because again, I take Bill's and Ken's point that these technologies are out there. They can be used in appropriate ways to address issues that aren't being addressed by the legal profession for whatever reason. So I think the goal would be, if it were me, to work with it, to understand the technology as best I could, and to look for times when lawyers aren't using it correctly and to make sure that they're complying with their duty to themselves understand the technology that they use.
Which has always been the duty, right? You're supposed to check your sites. So, Ken, but you kind of agree with what Jim's saying, right? Like Jim's saying, let's not try to regulate everything, but you gotta make exceptions for certain stuff.
I do, but I will raise, Jim, when you brought up your definition of legal advice, tax compliance and doing your tax return is kind of a specialized area where we let consumers do their own thing. But a lot of what you described would make TurboTax legal advice in some way, or if you applied that same sort of concept pre-AI to other areas of law or other types of things where you take facts that are very specific and blend them in with the law to get to a place where you determine, okay, is it a Chapter 7 liquidation or a Chapter 11 reorganization, bankruptcy? That's just be like an example where it would be very natural to kind of walk through the questions and get to something like that. And, is technology, especially with you add a LLM in practicing law or providing advice?
Hey everyone, Vicky from Percipient here. I just wanted to give you a heads up about a new service Percipient is rolling out in 2026, subpoena compliance services. If your company gets a bunch of subpoenas or data requests, Percipient can help. Literally the whole process. You just forward the request to us and Percipient takes it from there. We'll check if it's actually valid, flag any issues, and let you know about any objections. Then Percipient works with your team to gather and prep the data. You'll see everything in Percipient's secure portal: status, due dates, metrics, all of it. So you'll never be out of the loop. And my favorite part? If you're allowed to charge the requesting party for costs, Percipient software collects that money for you before we hand over the documents. Basically, Percipient handles legwork so your team can focus on the core work. If you want to chat about it, head to percipient.co or shoot us an email at subpoenas@percipient.co.
Bill, where do you think it's going to go? How do you think that the regulators can deal with this?
Well, I think that they're going to be unable to deal with it, and they're going to have to deal with the fact that they're going to be unable to deal with it. Ken sent along a little note here that I thought was really interesting that described the New York Senate bill suggesting liability for damages if a chatbot impersonates a licensed professional. I mean, when I'm querying it here, it always has a little caveat. Well, I'm not a licensed lawyer. You should consult with one. I'm just wondering if that in and of itself is, I'm not impersonating a licensed, a lawyer would be a way out of it. I think this is going to be about as successful as the 18th Amendment was in keeping us from not drinking. I mean, and eventually we're going to have to throw in the towel. Let me give you a slightly different point of view because it's coming from the applied research that I'm doing here. We can all sit here because we're knowledgeable white collar workers, and we can write good prompts, and we're astonished at the stuff that we get back. But kind of going back to my a lot of the research we're doing at Indiana University, we went out into the field and looked at the access to justice thing, went and did courtroom observations, etc. Is remember, legal rights are held by individuals. And so I've got a JD. I'm a pretty smart guy here. I can process these things here. But a lot of the people that don't have access to legal rights here wouldn't be the kind of person that would write in a clever prompt into a large language model. One of the things that the librarians said to us, we went to the public libraries in the 7-county area, because that's often when somebody gets a summons from a court, they go to just say, what does this mean? And the librarian said to us, they begged us, he said, don't think technology is going to solve it. We get people coming here over and over again. Tell me what this means. They want to have a conversation with a human. And so even if I could elicit from the machine this brilliant stuff here, I still need to articulate it in a way so the person with the legal rights can have the knowledge and build a trust where they feel like, okay, this is what I want to do here. That's a very human task, and that's part of the whole product solution. And so there's just a lot of variations. And I think when we start generalizing from a bunch of people that got college degrees and law degrees, how amazing it's going to be. We're not the modal customer.
Another good question I have for Ken then. Bill just mentioned that when these people come in, they want to talk to a person.
And a person they can sue if they get it wrong here. I trusted you. I believe you.
So, and even like at the highest echelons of law, where you get your most expensive legal work to law firms, a lot of people still want that. The general counsels want to go to their law firms. Tell us your take on what law firms need to do to really adapt to this as business is going to move away from them.
I think that another systemic issue that I've written about is, especially on the corporate side, outside counsel guidelines, tell law firms all the things they can't bill for. They discourage overhead. You can't bill for the time of an associate. You can't bill for research, even if it's like the nuances of the law that actually is critical to what your issue is. There are all these things that end up being line itemed out, and the only way that a law firm can actually, recoup their costs is to raise the rates, because they're discouraged from doing the overhead and putting the investment in to actually get better or to be able to deploy AI so that things are automated that the client expects to see. So I think that's another one of these challenges here. I don't have a really good answer, but I'll say at the high end, I still think that a lot of what it is, I want somebody that I can, sue or that's got my back. I think a lot of what high end work, whether
That I
it's
can blame. Nobody gets fired for hiring SCAD and ARPs.
right. No, 100%. That was where I was going with this is the M&A work or whatever. It doesn't matter that you can save a few bucks. You want somebody that's going to get the deal done, or when you're getting high bet, stakes bet the company advice, you need somebody to blame or to be able to say, look, I did the best. I got Kirkland and Ellis to do this for me or something like that. So I think that's a very important part. I do want to swing back over to the other extreme, which is like contracts and things. When I've watched attorneys type something into Copilot, they'll literally like type in a word. They don't even know sometimes how to talk or interact or prompt these systems. Whereas like I look at it and, me personally, when I get a contract sometimes, I'll run it through and ask, chat GPT or a language model, tell me about this or whatever. And not only will it tell me, okay, this is a fair agreement, but here are three things that are issues. This is why they're important. These are the legal background for it. Here's some red line language. And if you want to negotiate this, here's how you might approach each of those topics. I never have ever had in my career an attorney give me that kind of comprehensive advice. So to me, the bar is being raised even in some of these basic things in terms of what can be done.
Can I just say Ken and Jim, you're raising such interesting points, and I've long in my research talked about the two hemispheres of practice. Half of serving organizational clients, half serving people, and it's gone to really three quarters organizations, one quarter people. And in the organizational sphere, it really is about CYA. It's really about kind of covering your butt here, and so that Kirtland else will figure out how to make the most of these large language models, and their peers will as well. But it's just a completely different kind of kettle of fish. In other words, you can look at this thing and see this is beautiful advice here, but maybe the associate of Kirtland should get this because they're still going to want to be able to blame Kirtland. So you just hope that the associate of Kirtland is using it in just the way you described here that can really kind of up the game here. But I just think it's a different kettle of fish entirely when you start to move over to the personal side, where they're just such a vulnerable population that that's probably the wrong word, but they're going to use this, engage with this in a different way. And also, they can't afford the full machinery of the justice system. They need the best available off ramp. You want to find this upstream. You want a debt collection that never gets a default judgment. That kind of thing.
Jim, so to Bill's point, they're going to use it. They need more. So instead of regulators trying to say you can't use it at all and you got to check by lawyer, let's take baby steps. What's the first thing regulators can do to protect the vulnerable, as Bill mentioned, those that have less resources and less access to the attorneys? What are some baby steps regulators can do to kind of protect them from making missteps?
I know that regulators work with court systems on access to justice issues. I think our Supreme Court has one or maybe more efforts in that regard, task forces and things like that. And I think that's the place to start. When I started practicing in my very early career, I was a legal aid lawyer doing civil work on eviction defense and things like that. Eventually, I had to handle some family law issues because that was the really expanding need at the time. And I have some experience in trying to help serve an underserved population that does not know always what the stakes are in their case or how to handle what, as you say, what a complaint is or what a summons is or all of that stuff. And people need that level of advice, but they also needed me as the lawyer to go and fight the eviction for and with them. And part of that is the access to that professional. And I happened to be able to be working at the agency that would provide qualified clients that service for free. But part of it too is their access and their understanding of what is actually happening in court in the first place. And so I'd like to see regulators work with court systems on that. And again, I think there are efforts to do that, maybe like the Minnesota AI sandbox that you forwarded some information about as well could be geared toward that. That would help to allow some AI tools or LLMs to be used as a foundation to provide that initial level of understanding, and then maybe other kinds of services that the pro se litigant could use to move the matter along in court. But rather I'm proposing it or thinking of it in those ways because that would help to keep it from being a situation where the pro se litigant just uses an LLM thinking that's going to be the solution to fix whatever this whole thing is in court, which it first of all doesn't necessarily serve the litigant well, and it also transfers the risks and downsides of that basically to the judge appear, before whom the litigant is appearing. The judge then is the person saying, well, what is this? No, this is not right. And this is not operative, or it won't work. And now is the judge providing legal advice? They won't do it. So it's more of a headache that way. Whereas maybe if there's a stepped approach where an AI tool could be used to help with that initial understanding first, and maybe a legal regulator could assist in that way as well.
Ken, shifting gears just a little tiny bit, where do alternative business providers in legal, where do they fit into all this? How do you see them coming into play with the advent of these tools?
Two things. One is first, the business person in me thinks that, facts are friendly. So collecting data, especially, whether it's the Minnesota experiments or, what's going on in Utah, in Arizona with alternative business structures, are good things that allow for learning, to be able to play through. I think where managed services, legal services providers, if you will, fit into this are teasing out the lines between what is advice and what is information. Where do you need a lawyer to give advice, and what are things that you can follow instructions? And I'm looking at Bill on the screen here and his medical and industry analogies here, because I sit there and think, like, with contract and contract review, one of the things I did at one company I was at was we developed a playbook that was pretty comprehensive in terms of, this is our standard agreement. If you're going to work with this, you have these exceptions. And we had a sales director that had permission to be able to negotiate certain things based upon predefined rules and guidance that the attorneys had described. There are other companies that have an attorney sit in on every call. And I don't think that's an efficient way to go about doing things. So if you extend that to, say, contract review with a managed services organization, what's the credential? What is really needed to be able to follow, a clear, defined set of rules? And what constitutes legal information in that standpoint, or following a set of rules and knowing when you get to a certain point where, oh, this is outside the norm, I have to escalate this. And then you have a lawyer get in. I think that's really where it's going to be. So it's going to be testing a lot of things where you went to a lawyer because they were the only ones that knew the law. You had to go to a lawyer because you needed a contract drawn up. And there are aspects of that that I think are going to be teased out in a big way in the next few years. Otherwise, the investments that have been played through so far on technology aren't going to get a return.
Bill, what's your take?
Ken's raising all these great points, but I think that's really on the kind of organizational client side. I'm thinking about on the people law side. Chad, you know about this. We're now in the fourth semester of an initiative we're doing at the behest of the Indiana Supreme Court. We're trying to create allied legal professionals. It's the kind of the nurse practitioner stuff. When we describe this to township trustees, and they're the people in Indiana that have to interface with the indigent. I don't have money to pay rent. I'm going to get evicted. Can you, my electricity is about to get cut off. Can you help me? They're constantly interacting with this population. And they were the ones that were the most in favor of an ALP model. And they saw technology as being essentially worthless to them because these people, their population can't interact in a sophisticated way to get an answer. But they think it's possible. And I'm just going to be, this is a little bit crude here, but if Bonnie, who looks like them and acts like them and is from their kind of cultural milieu, can say, oh, this is what your problem is. Honey, you need to do X, Y, and Z here. It builds that trust, which is very critical. That's what's really missing from our system right now is faith that, oh, I have an answer to my problem. And in basically 3 minutes of legal advice, you spare a lot of hardship for people. And then they tell their friends, and that accretes trust in the system. And so lawyers are inappropriate to give this one. It's very repetitive. They're the guy or the gal in the suit. We need to have a kind of a different person to do this one. And it really does kind of close down the loop of comprehension, because we can train a cadre of people that know how to use LLMs and other things here, and they can be the bridge between the unmet need and the lawyers. And in Indiana, the last thing I'll mention about this one, what we're conceiving of is you have a lawyer and an ALP works underneath them, and the licenses are connected to one another. And so, in other words, it's not Bonnie working by herself. I'm vouching for Bonnie that are competent, and if she screws up here, I'm vicariously liable. That's a good system, in my opinion, and we will be using AI in this approach. I guarantee it.
I don't want to get too dystopian, but okay, so eBay for the longest time resolves the vast majority of their disputes without a person involved. This will happen at some point in the future where courts, it's just going to be, do you need people then? Do you need a hand holding then?
That's not dystopian. I think maybe just for the people that lose their jobs here, but who wants to go to court here? Does anybody feel that they're getting shortchanged by eBay's dispute resolution system? Not me.
I'm sure somebody does, but yeah.
I've always used the analogy of with all the cameras on automobiles, is there a point in time where there's enough sensors and technology that when somebody has a car accident, basically if you've opted into the system, you can basically receive a, hey, this is your settlement, this is what you're going to get based upon the damage of your car, maybe not your health. And if you agree with it and it's within range, you're done.
The insurance company may be driving that. Yeah. We're generally not the tip of the spear, but it does make economic sense.
Yeah. You raised another point in the article. It's I guess it actually cuts across the swath of both applications that people all use and the more organizational type of law. It's the argument I like to call wrapper versus model. And Ken, you say in there that legal innovators must leverage LLMs, but be mindful that they can be dancing with elephants. What's your take on that? Do you think that some of these pieces of software they're sitting on top of LLMs are going to be rendered obsolete because the models are going to get so good?
I definitely feel like you have to have data or some other moat or something that's defensible. And a lot of that can be the last mile. I did a lot of talking about when Anthropic came out and stock prices for Thomson Reuters and others went down 15-20%, that, there's a lot to be said for having 24-hour a day, 7-day a week service where you can pick up the phone and talk to a lawyer about your legal research question. There are a lot of different nuances about that last mile that I don't think organizations that operate at scale play at. But I think part of my point on this is that you do have, this is Gen AI to me is the poster child of the fourth industrial revolution, of this new industrial revolution that we're experiencing. And when you go back and think about that from a public policy standpoint and geopolitical considerations, where AI has implications on cybersecurity, on energy, and the race to build the infrastructure to create all these data centers to supply the compute, and the computer chips need to be sourced in a way that we aren't beholden to other countries. There's a lot of things going on there, and that's, I think, another place where go tying it back to the UPL discussion here. You don't want to have a regulator poke the bear and find that they're basically working up against OpenAI or Microsoft or the companies that represent a third of the value of the S&P 500 and are strategic to us winning this next industrial revolution. Those are some of the things that I think are kind of the bigger kind of helicopter up context to the discussions about how decisions get made in the context of legal, whether it's a vendor figuring out how do they dance with the elephant or the regulators doing the same.
Yeah, what about that, Jim? What about like Uber? They pretty much won, and Uber pales in comparison to these companies as far as value and influence. And what about that argument that, don't poke the bear?
I don't think regulators really will in the broad sense. That is, I don't see legal regulators facing off against OpenAI or Anthropic. There was the enforcement movement, if you will, against LegalZoom, for example, back in the 2000s and early 2010s. And that went the way that it went, which was partly successful for the regulators and partly not. And that is, in different cases, there were different outcomes. And ultimately, they kind of converged on the same point, which was LegalZoom modifying some of its operations to satisfy some of the concerns of the state bars, but not much else other than that. That was significant. I don't mean to downgrade what that meant for either regulators or LegalZoom, but it wasn't like the regulators went and vanquished a new industry or a new part of an industry. They changed it, but didn't kill it off. And now there are lots of other entities and companies doing not the same thing that LegalZoom did, but varying the model in some ways, incorporating what was learned from the LegalZoom litigation and all of that. So it didn't end. And I don't think that legal regulators really would have the stomach to challenge the concept of LLMs themselves. And I go back to what Bill was saying about who's to blame. And I think legal regulators that's a question that they ponder really a lot, and they want to hold individual lawyers responsible for individual bad outcomes. Right. And it's not that every client who says, I didn't get as much money out of my case as I thought I would, has a claim that a disciplinary agency will investigate. It's not that. It's that when the framework that a regulatory agency has is who has the law license and therefore who has the duties to comply with the rules of professional conduct, which in most cases are going to run toward clients, sometimes toward third parties related to clients, and sometimes to tribunals. They're looking at that's our target. And so, again, I think when you'll see more regulation about LLMs and things like that, it'll be targeting lawyers who have used it, quote unquote, wrong, and who have produced, by using it wrong, a bad outcome, and one that is determined to have violated the rules, much more than you'll see an attack on the technology itself.
Bill, as we wind down here, any famous last words? Where are we going?
I just love what Jim had to say here, that from the point of view of the lawyers using AI, because it's just like the temptation to use it, basically outsource a big part of my job, the heavy, lifting. And I think that one of the gifts that it's given us is kind of revealing that maybe not 100% of us have kind of good, judgment. And it's good it's good to reveal that, and does make the pretty strong case that there's some people out there that need to be regulated, and held accountable. It's incredible what we're witnessing, the amount of lack of diligence, 1.3 violations.
Ken?
Yeah, I was just going to say, well, first off, the congratulations to the Indiana folks on the Indiana Hoosiers. I was on
Thank
the
you.
other side of the field. My son, is affiliated with the Miami team. So anyhow, I think, kind of closing out from my standpoint here, I think, I just think it's going to be so interesting to see how this plays through with people, process, and technology across the board. Because to use this technology properly, it's going to have to change the way you approach things. So you may be able to create a first draft of a brief or something, but then you're going to have to look at it differently than what you did when you had a human drafting it. So I think there's just so much learning, and we're so early. Whether you call this the first inning of the baseball game or other things. I think, everybody kind of feels overwhelmed. Nobody knows what to do, but we can look back on history and see what's happened when there have been other inflection points, other technology disruptions, other industrial revolutions as guides to help us, figure out how to navigate. And I think the history of that will kind of bear out that regulation will tend to follow once things get to a new normal.
Jim, what do you want to leave us with?
I agree with Ken's last point. I'll say when I started at the disciplinary agency in 1999, it was Redwells and bankers boxes as far as the eye could see, and our computing was word perfect. And then we eventually moved to Windows, and eventually, kept going down that road. And I think, in one reporter's opinion, we were one of the more technologically capable state government agencies for all that. So these things do move slowly in that world, and regulators do follow just per force. I don't think they want to be followers. I think they want to be seen as leaders, but they have functions that, as I say, are about tracking what lawyers do. It's a human behavior business, and they start looking at, well, what are the humans doing today? What are our lawyer humans doing today? Oh, they're using this technology, and what does that mean for us? So they are reacting, just as they react to a more ordinary complaint about alleged lawyer misconduct. They investigate it, they see what happened, and they determine if they need to do anything. That's what they're going to do, and are already doing to a certain extent with LLMs and expanding legal tech.
Gentlemen, I appreciate the time. If people want to get a hold of you, where do you send them, Bill?
I'm easily findable on Google at Indiana University, Maurer School of Law. So just find my faculty webpage, and there's my email and my office phone.
Ken.
Ken Crutchfield, springforwardconsulting.com. LinkedIn is easy to find me, and I publish on Above the Law and with Bob Ambrosi on Law Next.
Jim.
rsmdlaw.com, or I'm on LinkedIn, and you can find me there as well.
Okay, that's a wrap for today's episode. As always, we really appreciate you listening. If you want to subscribe, you can find us on most major podcast platforms like Apple, Spotify, Google, Stitcher, etc. Also, if you like us enough, I hope you leave us a favorable review. Thanks again for listening. Until next time, this has been Technically Legal.